Hi everyone. I would like to welcome you all to this ADR Law Week. We are here for a panel discussion on future of arbitration in ESG within the BRICS countries. And I have an amazing panel with me today. I'll be introducing each panelist very shortly. I have an amazing panel who can give us inputs on different aspects of ESGs within BRICS country, and also Anna will be giving us a perspective on what is going on in Canada. So, of course, ESG has become a term which we see on LinkedIn everywhere, which has become the buzzword now. Earlier, what used to be a soft compliance mechanism now has become a strategic and a regulatory imperative. So, it's very important to understand ESG. It's very important to understand arbitration in ESG, and I'll be bombarding the panelists with a lot of questions today so that all of us get clarity. And we want to keep the panel quite interactive. So I think you have a chat option on your right hand side. You can use the chat box for the panelists. I will be taking up questions at the end of the panel, and we will try our best to answer as many questions as we can. So to introduce the panelists to our audience, we have Luis with us. He's partner of environmental climate change, ESG, and litigation regulatory enforcement practices of Duell and Trecker associated to Mayer Brown, and assists various clients across energy and other industries. He's also a chairman of Brazilian American Chamber of Commerce and and is also member of core member of Mayer Brown Global ESG Group. We also have Annie with us. She's head of Americas at Just Mundi, a legal tech company at forefront of AI and international law and arbitration with respect for leading companies' business strategy in Americas. She's also an arbitrator, mediator, and is a fellow at CIR. We have Danielle with us. She's an arbitrator. She's been she's over 25 years of experience as a general counsel and sustainability director in in automotive industries. Like she's worked with Michelin, Volkswagen, and many other companies. So, and we also have Dr. Niteesh Upadhyay with us. He'll be joining us shortly. He's an associate professor of law at Dhirubhai Ambani University School of Law and has over 14 years of teaching experience. He is an international research scholar, a research advisor at South Ural State University, American University, international research fellow at University of Milan. I welcome all the panelists here, and I'm looking forward to your inputs on the session, your inputs on the different questions that are coming in. But to set the tone right, to set the stage, I would invite each one of you to give your inputs on the topic. Maybe associate it with your experience, your expertise. So, Luis, can we start with you?
Thanks, Mahak. Perhaps the ladies first, and then I follow the ladies.
If I may, as I have a double hat here, as I'm part of the
Yes.
organization committee of this conference, I would like to thank all of you to being here with us and have been accepting this invitation to be here, and especially to thank Arbitration Channel, Lauro Parente, and all the staff that are behind the scenes working for being organizing this with us. Without them, we will not be here broadcasting this for the whole world. And then good morning, good evening to all that are listening to us. So thank very much to all of you, ladies and gentlemen. This has been actually a dream for Daniel, for myself, and for Elisaveta, a Russian colleague of us, to put ESG and arbitration together to really make two topics, strategic topics together that need to be talked as one for strategic business and strategic dispute resolution prevention, actually. So thank you very much. And maybe then I can give the floor to Annie Lespérance now, because I was just welcoming everyone. Thank you.
Well, thank you, Daniela, and good morning, good afternoon, good evening to those who are joining us remotely. It's a real pleasure to be here. Thank you for the invitation, Daniela. Thank you to Danielle and to the arbitration channel and to our moderator, Mahak, and my fellow co-panelists. Obviously, so I'm a Canadian national. I don't come from a BRICS jurisdiction, so I can share some, insights throughout the panel on Canada, as I'm a Canadian lawyer. But also I wear the hat of Head of Americas at Jusmundi, which is a legal tech company. So I'll share some insights throughout the panel more on the tech front as well, and how can technology help maybe prevent some of these disputes and help resolve them as well. But maybe in terms of more kind of general opening remarks, I think as the only non-BRIC member on this panel, I think it might be interesting just to share some geopolitical remarks on ESG to start this panel discussion. I think ESG is definitely at a crossroads if you're following the media. In some parts of the world, particularly in the US, we're seeing a significant backlash, and ESG has become politicized, even weaponized. And that's led to regulatory rollbacks and a chilling effect on corporate ESG disclosures. And this is where I think BRICS countries really truly have a real opportunity, not just to react to global ESG trends, but also to lead the way and pave the way moving forward. And doing it in a way that reflects, the BRIC countries' own development priorities, cultural contexts, and geopolitical realities. And obviously, with more, ESG obligations come, potentially ESG-related disputes, and arbitration is especially for cross-border disputes, is truly probably, I would think, one of the best forums to conduct these types of arbitrations. And again, BRICS countries have can lead the way and pave the way in terms of thinking beyond traditional models for arbitration as well. And so I see this as an opportunity for these countries to position themselves as leaders, especially as some of the traditional states that have been leaders in this space are taking a step back.
Thank you, Annie. I think you set the tone right, and Daniela, thank you for the very warm welcome. We're glad and honored to be here. Now, Luis, moving on to you for the opening remarks on the topic.
Great, thank you, Mahak. So once again, I would like to salute the arbitration channel and Danielle, Elisaveta, for taking this step of organizing a so relevant event. To put together ESG and ADR is very important these days. We have been a lawyer in the environmental arena, let's say, for a couple of decades already, and I have been involved in several litigation matters, controversies. Some of them we on the traditional arbitration practitioners in Brazil and in other Latin American jurisdictions, and even worldwide. We kind of see a view of like environment and arbitration were two electrons that repel themselves, but they are not. And we have been building with the practice on the litigation side involving environmental and ESG matters. We have been seeing one clear trend of an increasing acceptance of the idea of arbitrating environmental issues. And this is, I think I'll be able to comment in more detail about this with examples of my practice in Brazil. but we are seeing transactions with issues connected to environmental issues all the time in the practice of law in Brazil. So this is one trend that I also very happy to see being built over time. And now we definitely have an increasing acceptance of the idea of arbitrating environmental issues. Another trend that we have been seeing a lot is some cross-border stakeholder litigation, increasingly involving environmental and ESG matters. So just to give some examples of the major dam collapses that happened in Brazil, like 5-6 years ago, they are now being litigated in cases, environmental accidents and damages that happened in Brazil. They are being litigated in British courts, in Dutch courts. So it's a clear trend of cross-border litigation involving environmental and ESG matters. We are seeing that picking up in the last, let's say, 5 years or more. And finally, one third trend that I expect to be able to comment in our panel today is also an increase in climate-related disputes in Brazil and abroad. We even today had a very important ruling in German courts involving a Peruvian farmer in a very high-profile and important climate litigation case that I also expect to be able to comment a little bit more about this increase in climate-related disputes and that we have been seeing in the last 5 years, let's say.
Thank you so much, Luis. And yeah, moving ahead from here, you highlighted about the trends, and you mentioned about how there is a requirement of making a shift from the traditional models. Another amazing thing about this panel is we are from different jurisdictions, so it's important to understand what is going on where, so that we can learn from each other, we can learn the challenges that each jurisdiction is facing. So now I would request each panelist to give us comments on how do you think environmental issues are arbitrable, specifically in your own country. What are the challenges that you're facing? What are the trends that you're following? What is the lesson that others should take from your jurisdiction? And something that can be adopted. So maybe I'll start with you, Luis, again. Since you've concluded with trends, maybe we can take it ahead from there, and then we can move ahead.
Mahak, if I may pass the word to Daniela, because Daniela, I think she'll have some.
I have okay.
First, yes. Daniela will have some.
I really appreciate your gestures of ladies first. I had a very special question for Daniela after this. But yes, Daniela, if you can start this, and then
thank you.
Daniela was saying that she has some good comments on general ESG issues, and then with that in mind, we would build on talking about specifically of the practice in Brazil.
Thank you, Luis. Yes. Actually, I always like to remind the roots actually of ESG, because it's the trends. It's always a circle, And Annie was talking about the slashback that we are suffering nowadays around the world, actually. And as I work with sustainability since 2001, when it's even not called yet sustainability, it was called corporate social responsibility at that time. When I was working with Michelin as a director of sustainability at that time, I like to remind the roots. You know that corporate social responsibility was invented by Howard Bowen in 1953. So this is quite something amazing for me. And actually, he wrote a 300 pages book about the social responsibility of the businessman, saying that businessmen should go beyond the legal obligations, and businessmen should think about the well-being of the employees and societal responsibilities, and that they should comply about environmental issues, about well-being, about the well-being of the society, and this was in 1953. And then the environmental concerns started in 1970s with the ozone worries, and in 1972 it was a very important milestone when a think tank called it was called the Club of Rome in Rome. They actually commissioned some guys from the MIT to design a model and to model the relationship between population, industrial production, food supply, resource depletion, and pollution around the world. And actually, this model had a conclusion very important, and they conclude that if this balanced would not be actually, how can I say, how can I say, if this would not be checked, the balance would not be checked during this balance, this would clash within a century. So they said the humanity would exceed Earth carrying capacity within a century. We had finite resources and exponential growth, and this is not a good balance. This was in 1972, and they gave us a very, very good and important report called The Limit to Growth. Since then, we had a very important notion about the Earth limit. Well, this is the story about the start of sustainability. And then the first time ESG appeared as the three letters together was in 2004, when the UN commissioned financial institutions to find an index to a financial index for sustainable growth to put into the financial world. And then 12 years later, Eric Fink, the BlackRock CEO, put in his annual letter that this could be a good index to the financial world, to good decisions for a non-financial metrics, to perenne and sustainable valuations, add values. So that's why in 2016, ESG started to be in the financial world again, but it was created in 2004. So this is just for us to understand that it's a long way that the concept was created, and this is the root of ESG that came a very long way from 1953, from now 2025, with backlashes all around this long story all the time, and sometimes it comes back and sometimes, but all the backlashes that I would like to say may change the rhythm, but they don't change the goals. the way where it has to go. That were my remarks. Thank you.
Thank you so much, Daniela. Thank you for highlighting your experience. I'm very sure with your actual hands-on experience in sustainability in ESG, we're going to get a lot of learnings today in this panel. And thank you for highlighting the need for balance and, of course, very beautifully explaining how the concept of ESG actually evolved. So now I would move to Annie to give us all perspective and how things are there in Canada and in context of ESG.
I'm happy to. I guess the question that was put to us as panelists is whether ESG disputes are arbitrable, and I can speak to that in terms from a Canadian perspective. I think, in Canada, the arbitrability, and I assume it must be the same in other jurisdictions. I would think it must be the same in Brazil and other jurisdictions, and perhaps in India. You can comment on, Mahak. But, the arbitrability of environmental issues really depend on the context. So in Canada, for example, if a dispute arises, from a contractual relationship and embedded in there's an arbitration, clause, then yes, environmental issues would, fall under that arbitration clause and would be generally arbitrable. So these types of disputes are treated like any other type of commercial dispute. And as we're seeing more and more ESG clauses being embedded in commercial contracts, then I would assume that we're going to see a rise in the number of ESG-related arbitrations in Canada from a private sector kind of perspective. That being said, when it comes to public law matters like environmental assessment or regulatory enforcement or even like constitutional challenges, these types of disputes are obviously not arbitrable. These issues would fall under the jurisdiction of Canadian courts and administrative tribunals, obviously because they involve a public interest and statutory interpretation. So in other words, you cannot arbitrate yourself out of complying with environmental regulations. So that's more like in the commercial kind of sector. If we move now to more like investor-state arbitration, there's obviously, I think we've seen a growing space in terms of investment arbitrations where environmental issues are being raised. And for example, and I can talk about this a bit later as well when we talk about the rise of climate change related arbitrations. Canada has now a new model BIT that provides for certain provisions in terms of climate change, but I'll get to that later when we move to that topic. But if we look at treaties like the CETA, which is the free trade agreement between Canada and the EU, well, there obviously foreign investors can claim against the Canadian government, and the environmental regulations are often at the heart of those disputes. And then arbitrators are being asked, to weigh environmental protections against investment protections, which is, in and of itself a fascinating and evolving space, and we can dive into that a little bit more later in the panel. So, in short, environmental issues can be arbitrable in Canada, especially in commercial cases and treaty-based contexts, but with clear limits in terms of when it comes to public law issues.
Thank you, Annie, and thank you for highlighting specifically from perspective of Canada. And I think I agree with you that it would be common to all jurisdictions majorly that they are treated more like all other commercial disputes. I think we had a great insight on how things are there in Canada specifically after hearing you out, but I'm looking forward to more inputs from you on the other questions. Moving on to our fourth panelist has joined now. I would now pass the floor to Dr. Niteesh Upadhyay to give us insight on the same question which has been put forth to the panel about arbitrability of ESG disputes.
Hello, good evening, everyone. My voice is loud and clear.
Yes, we can hear you.
Yeah, and sorry for joining late. I'm a little old with technology, so I was just trying to match up how to join. So I have three devices with me, and finally, I was able to join from one device. So when I'm talking in terms of ESG, I'll give you a brief, about when I was researching. And there are a lot of data related to ESG when you're talking in terms of Europe and US. And but there are fewer data when you're talking in terms of India in terms of ESG. And when you're talking in terms of ESG, even there is a trend that I have seen in Europe that it is water downing now. So they are reducing the impact of ESG added. So whether you go with any legislation that was there, any guideline framework that was there, whether it was um, CSRD guideline, which was Corporate Sustainability Reporting Directive, or Corporate Sustainability Due Diligence Directive, CS Triple D. And as part of their omnibus package, they have actually removed a lot of companies and a lot of employers who were earlier part of CS Triple D or CSRD, saying that if you have these many employees, then only you have to do a ESG reporting. So somehow we see that in Europe also, to increase the business or to make financial sector investment viable, have FDIs and all, it has been watered down. So ESG importance have gone a little down in terms of Europe. Whereas when I was seeing how is the US, since a new president is there, how it is working, how the Security Exchange Commission is working. So even they have been not very vocal about ESG. And whether you are talking in terms of CBAM, which is carbon border adjustment mechanism, whether you're talking in terms of EUDR, that is, EU deforestation regulations and all, ESG have been on a back front now. And it's a right forum where we're talking in terms of how ESG disputes are going for arbitration, or let's take for any other alternative dispute resolution mechanism. Whereas the concept itself is under a threat that I have studied. That's my take on it. That it's very important, especially for BRICS nation, because we all the BRICS countries are developing, and at particular point we have to manage ESG norms, ESG guidelines, and also we have to see the development that we are looking forward. In India, like SEC is there. In US and India, there is SEBI, which talks about ESG. Whenever you talk in terms of ESG in India, people will confuse it with corporate social responsibility, which is CSR, where India is one of the few countries where corporate social responsibility is mandatory for certain sect. If you have a particular turnover, let's take 1,000 crores or a profit of 5 crores in a year, then you have to contribute 2% to the corporate social responsibility activities. But that's part of company law, and that's you have to do something mandatory. Whereas when you're talking in terms of ESG, there is no as such guidelines as it is in company law. SEBI has created something, but it also has watered down. It has said we will go phase wise. So earlier they said that 1,000 companies with so and so has to do the ESG reporting, and then they have come up with the business responsibility and sustainability report, that is BRSR. And they said that we will do it phase by. So the first phase, 2023 to 24, it will be top 150 listed companies. Then 2024 to 25, 250 listed companies. 2026 to 27, it will be top 500 listed company. And the threshold is not gone up. So earlier till 1,000, now they have also reduced the importance of it, only having till 2026 to 27 only 500 listed companies to give and fulfill the ESG norms and regulations. So the overall, I'll say the concept, which how important and the importance of this concept, it was there around 2 years back, has actually lost its charm. There are countries in Europe, India, and around the globe that have kept ESG at a back foot a little, and economic prosperity and investment at the front foot. When you're talking in terms of ADR or arbitration in ESG disputes, in India, it is negligible to a size. There are no doubt certain construction industries and construction arbitration do have some ESG clauses and they do arbitration on it, but they are not very much known. So when you're talking in terms of ESG and ADR, ESG and arbitration in India, it's quite a new domain of research, and very few people are knowing about that. Okay, this is the way how we can resolve a dispute related to ESG, and then most of the time, they even get confused with CSR, which is a government regulation which they have to follow, and no kind of arbitration or anything is possible because it's a legislation that you have to follow being in India. Whereas ESG disputes can have a probability where they can be resolved by alternative dispute mechanisms. So this is how, when I was researching, I came to know that, or I was happy that, okay, no doubt there are some significant moves in India also about ESG, and there is some awareness in last let's take 4 to 5 years about ESG. CSR, no doubt we are being aware since long. 2007 was the first guidelines by Heavy Metal Ministry and Ministry of Corporate Affairs in 2009. Then Mines and Mineral Development and Regulation Bill 2011, then Companies Bill 2011, which could not pass, and then finally Companies Bill 2013, which came into picture, and then CSR become a law under Section 135 of Indian Companies Act. And with it, there have been, every time after a few years, 2016 guidelines are there, and then 2018, 2020, keep on revolving. So even at times, CSR, if you do not contribute to your CSR and you are responsible for it, you're falling in that bracket, you can be punished. But now that thing is not there. It has been removed. It only says that you can have not a punishment or an imprisonment as such, but can be penalized in terms of fines and compensation. So CSR has a long history in India since 2007 to 2025. I did a research in way back in 2010 and 11 about CSR and viability in India and how it will work. But ESG come little late to the domain, especially to the academic research and all. Maybe 2019 and 20 was the first when people have actually started talking about it, and the government was also at the similar time was discussing about the same. So it is hardly 6 7 years old concept in India, and it requires a lot of input from legal professional arbitrators and academia, where it could be actually ESG disputes can be resolved by the arbitration. So thank you very much. This is all from my side.
Thank you so much, Dr. Niteesh. Your insights, your inputs gave us a clarity on what the Indian scenario is right now. And of course, you very well highlighted all the legislations, all the policies and everything. And also, of course, how it is being taken recently in Europe and US. Now, last but not the least, Luis, I would invite you to give us, inputs about Brazil.
Great. Thank you, Mahak. So on the question, it was great that Daniela spoke before about all of the developments that we had in the international arena with regards to ESG. We also were able to hear Niteesh talking about some important developments that we are seeing in Europe. The UGR should put a lot of pressure in the litigation side. We should be seeing in the coming years a lot of new litigation cases related to the UGR. And it was also great to hear from Annie about how this issue of the arbitrability of environmental matters are in Canada. And in Brazil, it's quite the same, Annie. So when we're talking about commercial issue, it's very usually arbitrated. We ourselves here at our law firm are involved in a couple of arbitration matters these days, connected with some issues related to an M&A transaction, some environmental issues related to an M&A transaction from assets that were sold. One of these arbitration matters involves chemical companies that has assets in Brazil and Argentina. this company was sold to another to a Swiss company, and this Swiss company, they have some issues in relation to the let's say the situation that they found out when they started operating the assets. So there are some discussions being arbitrated in New York because of this M&A transaction. We also have another arbitration matter here involving also an M&A of a fertilizers company that they're also finally the arbitration was initiated, but the companies and our clients had reached a settlement in this arbitration dispute. So this is really happening in Brazil for some time, but this issue of the possibility of environmental issues being arbitrated is one topic that I was able to write an article about in the first issue of the Brazilian journal on ADR, and we have to remind to have in mind that we have, as mentioned by Daniela, we have some international treaties that specifically indicates the possibility of using arbitration as dispute settlement. So just to give you some examples, we have the Vienna Convention on the protection of the ozone layer, Article 11, Item 3A, directly indicates the possibility of using arbitration for dispute settlements in issues connected with that convention. The same happens with the UNFCCC, the Climate Change Convention, that also refers to arbitration as a method of dispute settlements. And finally, the CBD, the Convention on Biological Diversity, also refers to arbitration as a method of dispute settlement. So we have these embedded international treaties. In Brazil, as I had the opportunity to write in this article, is a very controversial issue, not on the commercial side, but to be able to arbitrate environmental issues in a broader way. And I would say that the main difficulties in this relationship between arbitration in environmental matters, they are connected with the facts that there is a legal requirement that you can only submit to arbitration if the issue is negotiable, and also if we are able to express the rights under discussion in a financial way. So these are requirements from the Brazilian laws. So we have been moving forward in trying to conciliate and check if these requirements are there in any specific case. And the difficulty lies on the fact that the environment is known in Brazil as a collective or common right. So some understands that the environment's interest could not be involved in transactions, and that the environment could not be financially expressed. But these days we see that even in practice in Brazilian litigation cases and otherwise, that these two aspects are every day more present. So we can see that environmental issues can now have a financial express, and that actually this is good for the environment. When you put a value in environmental assets, we put a value in nature, when you put a value in the environmental service provided by nature, we are more eager to preserve, and we're more eager to deal more carefully with those assets. And also transactions happen every other day in the Brazilian environmental litigation practice. So public prosecutors in Brazil, they are very active, and it's one common instrument of the environmental practice in Brazil is an agreement that public prosecutors usually reach with companies in relation to recover the environment in a situation that a pollution occurred. So we are in the practice of environmental law in Brazil daily negotiating with some aspects of the environment. not really if we are going to recover or not those environmental damages or that pollution events. Of course, this is unnegotiable, but it's negotiable the way we are going to do that, how we are going to do that, in which time frame, so that it's effective for the environment. So in this article that I was able to write back 6 years ago, we go through all of these facts of the daily environmental litigation in Brazil that calls for, let's say, a more conciliatory perspective on the arbitrability of environmental aspects beyond commercial agreements and beyond only commercial aspects.
If I may, I have a question for you, Luis. I'm very curious to hear you on. You share some examples of the commercial disputes that you've been involved in that had environmental issues embedded in them. I'm just curious to see, like, do you see a shift in terms of, I think, in the past, it seems like commercial disputes, at the heart of them, it wasn't environmental issues. It was just environmental issues were just an afterthought or, a sub issue within the global dispute. Are you seeing now more and more a trend, maybe in Brazil, and maybe Niteesh, you can speak to your jurisdiction, as to commercial disputes that are purely, environmental? See what I mean?
Yes, as the environmental issue become every day a more important issue for the company's lives. When we are negotiating a transaction, an M&A, this comes as a potential no-go for the M&A transaction. This becomes a very important topic. And when these clauses are not well negotiated in the M&A phase, then we have some consequences on litigation that arises. Usually arbitration clauses apply, and then we move into arbitration. There are, in their core, negotiating and dealing with issues connected with environmental events, environmental pollution events, environmental aspects connected to environmental compliance that directly impact the activities of those assets that were the scope of the M&A transaction. So yes, we are seeing arbitrations taking place with the core issue at dispute is an environmental issue.
And if I may, as we're talking about trends and we're talking about future arbitrations and ESG, and especially the E and environmental, that the climate treaties set public laws and obligations. And these law and obligations, they actually flow into private contracts via national laws. And these will promote actually market standards and eventually disputes. And we're talking about renewable energies, sustainability linked finance disputes and contracts of carbon markets. We're talking about carbon markets as well. PCA optional rules, environmental disputes as well. I mean, we have such a huge amount of topics. Certifications of CEOs, carbon markets that will need all the technologies related to that. It's huge because all the carbon markets will need blockchains, will need certifications. So this will really flow into arbitrations. And we will. I think that it's a topic we'll probably talk today as well. it's about the arbitrators' profiles, you know. This is something I have been thinking about to deal with arbitrations in ESG with these kind of topics, because it's a new world that is rising.
Thank you, Daniela, and thank you, Luis, for highlighting it so beautifully. Before moving ahead, if any of the panelists has any other comments on this topic,
To Daniela's point, that we are seeing already some arbitrations being initiated. Thankfully, they were already settled, but in relation to agreements related to the development of carbon credit projects. So we have a case with a Mexican company which hired a consultancy that was, let's say, not so diligent in putting the expectation in relation to the generation of carbon credits for one specific project. And when the project was finally generating the carbon credits, the carbon credits generated was like kind of half what was expected by this Mexican client. And this was due to, of course, there's a lot of technical issues there, yes, methodology that applies, but that arise a notification, a notice from our clients to initiate arbitration against this consultancy company that built their PDG, or how we say in carbon markets, the plan to develop the carbon credit projects. And thankfully, this was settled, but there was an arbitration clause over there, and there was a notice to initiate arbitration to discuss that specific topic. We saw another one happening in the beginning of this year involving a British company. So the other day, last week, we were negotiating carbon credits, ERPA, a purchase agreement for emissions reductions, with a client in a very innovative bioenergy carbon capture and storage project in Brazil, a BRICS project in Brazil. And we were very attentive to having an arbitration clause over there. So just to give you some examples from my practice here of how we are seeing arbitration jumping into as a very important method of dispute resolution in agreements beyond only M&A transactions, and also other agreements with service providers and with the purchase of carbon credits.
Actually, I'm very happy to hear that, Luis, because I always advocate for actually arbitration or escalating clauses to be the very much sustainable way to deal and to bridge this kind of topics, because if there is no this kind of clauses in those topics, this would not be able to deal with. I mean, this is not sustainable to the kind of it's a global issue with no way to local way of dealing with. So I'm happy to hear you have been dealing with arbitration clauses in this kind of topics.
Thank you so much, Daniela, Luis, Annie, and Dr. Niteesh for just giving us insights about everything. And I've taken quite a lot of notes while all of you were speaking. So of course, I'm also getting to learn a lot. Moving ahead, keeping time in mind, the next question I'm putting it to Daniela to begin with. It's about as we look ahead, environmental issues are increasingly transitioning into climate disputes, and these two terms are used interchangeably. They're different in nature, scope, and urgency. How do you see this kind of shift in influencing arbitration in practice in your jurisdiction? And to the panelists, maybe we can speak about nature of climate disputes, the need for specialized arbitral frameworks or tribunals, or role of treaty obligations and investor-state dispute settlement in climate-related arbitration. Daniela, thank you so much for suggesting this question. The panel would not have been complete without this, so the floor is all yours.
Actually, it's a question. It's a question for everyone, but this has been in my mind, and actually, I'm launching. I'm founding and co-founding with a friend, a dear friend of mine, Yannick Vincent, in France, a think tank called the GLASS Forum, Global Arbitration and Sustainability Forum, with four very well-known professors in France to think exactly what we to research actually topics, how to answer this question. So I will not be able to answer your question, but not only in Brazil and not only in BRICS plus countries, although I think that in BRICS plus countries, we have a very similar social and economic, sometimes in different sizes, but very social and environmental conditions, similar conditions. So we have sometimes, pressures from the world, developed world, sometimes social pressures, and we need to develop, but we have environmental to keep and social to develop, and industrial to keep developing. And sometimes we have a bridge between environmental and academia to keep together between BRICS plus, to work together. And it's easier because we understand each other sometimes better, and sometimes we can unite strengths and understand better our each other problems. But the think tank I am co-founding, and I have been, we are really launching the logo, and the colors and the pattern of colors have been chosen this week. So it's really, really new. We're gonna build the site, and if you follow up, we're gonna put in my LinkedIn, and we're gonna have a site the next months. We're gonna actually think about what arbitration and the sustainability will need in the future to solve global problems, because I don't think that we are prepared as we are nowadays with the features we have to solve the global problems, the climate global problems, to solve the urgency and the climate problems that are arising, and the urgent problems that will come to solve by the arbitration as we are today. I don't think that we are the mechanisms we have are built to solve the problems. So I would love to hear my co-panelists projecting in the few years the climate urgencies and social problems that will arise, how they see arbitration in a futurist way.
Thank you so much.
No, I was just going to say, Daniela, I want to be involved in your think tank. Looks really interesting.
For sure. Everybody will be more than welcome.
Fantastic. No, it sounds really, really interesting and much needed, actually. Yeah, I think, thinking of, climate disputes, they're more complex, they're more urgent, they're global in scope. They touch from everything from, emission targets to climate-related disclosures. So the nature of these disputes in and of themselves are, is different, and they involve, multiple stakeholders, scientific uncertainty, and long-term impacts. I know the ICC did launch a task force on arbitration of climate change-related disputes, and they have issued a report, and I invite all of you to go consult this report. They do, in their report, highlight the need for, specific procedures and model clauses and for specific, climate-related disputes. They do highlight, the need for specific expertise and again, tailored procedural rules because of the unique nature of these disputes. I don't know if it goes far enough. Maybe your think tank, Daniela, will go further in the reflection. But it's a start, at least, and it's a good sign that these institutions are already thinking ahead and thinking of these types of disputes and their own specific nature and how we can adapt, current procedures, arbitration procedures to those specific types of disputes. I know Canada, for example, if we move a little bit into the realm of investor-state arbitration, in our model BIT, there are specific procedural innovations. Well, first, there is a carve-out for the government to be able to regulate in terms of climate change, so that doesn't fall necessarily, with new legislation, on climate change would not be necessarily considered as expropriatory under the treaty. But further than that, this model BIT provides for the submission of expert reports, and also, and perhaps more importantly, the participation of non-disputing parties in arbitrations, so that communities that are affected by some of these regulatory changes in terms of for climate change purposes might be able to participate in those hearings. So I think that's an interesting and novel procedural aspect, I guess, for climate change related disputes. And then what's interesting as well is if we look then more to the kind of commercial sector, Canada has launched the Sustainable Canadian Agriculture Partnership. And this is launched by the federal government along with the provincial governments and territorial governments in Canada. This is a $3.5 billion investment aimed at strengthening the resilience of the agricultural sector. And as you can imagine, that this is a sector that is very much, can be very much affected by climate change. And so within that agreement or that partnership between the federal government and the provinces, the agreement includes risk management tools, such as crop insurance for the agricultural sector in Canada. And this crop insurance, allows for arbitration as a mechanism to resolve disputes between insurers and the insured parties. So I think it'll be interesting to see the rise of arbitration in the insurance space.
Yes.
In light of, because insurance companies are very much affected by some of these climate changes effects. And so it'll be interesting to see that. I mean, this is a specific, and I'm glad the Canadian government is going forward with arbitration, those specific kind of instances, but the insurance industry as well will be affected by this. So it'll be interesting to see in that space as well what will occur moving forward.
Yeah, thank you, Annie and Daniela. Congratulations on the think tank that you're coming up with. It's a brilliant idea and actually the need of the hour at this now. So, of course, all of us would love to be part of it. And Annie, of course, you've highlighted about the complexity, the urgency of the climate disputes. You've highlighted the ICC report, ICC task force report. And of course, how Canada is moving ahead in this aspect. Moving ahead, I would like to invite Dr. Niteesh to give his inputs on this question.
Thanks, everyone. I'll first start with it's good to start a think tank. My university is starting a full-time LLM on ESG and carbon market. So they're trying first time in India. I think is the only institution with such a program at postgraduate level, and we are also having a conclave on the 7th in Delhi on discussing what will the modalities and all. When we're talking in terms of climate disputes, especially in India, it's a little different than other countries because we are a country, common law country, but we are highly regulated by our codes, especially when you're talking in terms of climate disputes. We have National Green Tribunal, which talks about basically discussing all the climate related issues. And then we have our high courts and Supreme Courts basically to deal with anything that has to do with climate. And there are, no doubt, a lot of good interpretations by Indian courts when you're talking in terms of climate disputes, including stating that climate is an important part of Article 21, which is right to life, and it's also part of right to equality, which is Article 14 of Indian Constitution. And we have to make sure that climate change and whenever there is a climate dispute or climate related issue, NGT and these courts are able to take care of it. So when you're talking in terms of arbitration and climate disputes, they basically do not find a much place in Indian scenario. Because arbitration usually happen more for the commercial nature rather than for environmental disputes in India. And no doubt there are a lot of think tanks also in India which have started working on ESG and on climate disputes, and they're trying to work on a model where public, private, and people all can come together, and if they have any issues related to climate change and climate disputes are there, that can be resolved. But it's more of not coming from from specific. No doubt we have a lot of legislation related to air, water, land, and all set of pollutions that you talk about. But basically, NGT, Supreme Court, and High Courts take care of environmental disputes rather than arbitration, which is, I think, less time consuming and could be mediation, especially, could be something really we can look forward for in terms of climate change disputes. Thank you.
Thank you so much, Dr. Niteesh, and thank you, of course, for highlighting mediation as well. I'm a very pro-mediation person. I love mediation as a mode of dispute resolution. Last but not the least, again, Luiz, how would you like to wrap up this question, and what are your inputs on this?
Great. So thank you, everyone. I think I gave some examples already of agreements involving carbon markets, carbon projects that they have arbitration clauses, and we are seeing this in our daily activities here at our law firm. But I would also like to highlight that we have a clear trend of climate litigation picking up. And if you are not aware about it, there is a report from the Grantham Institute, or from the London School of Economics, that should be already in its 5th or 6th year, that follow up all of these trends. And there is a clear trend of picking up of litigation cases. And we have several different types of climate litigation cases. We have those cases that are focused on the corporate ambition of a given company or corporation. One of the more important cases in relation to corporate ambition is a Shell litigation case in Dutch courts. So Shell, it was a defendant in a case brought by some NGOs, Mil Defense, against Shell because in their understanding, Shell was not complying with the obligations that they imposed themselves. So with their emissions reductions policies. So this was taken to Dutch courts. The appeal, there was a ruling, a very important ruling, that recognized the importance of the Paris Agreement and the importance of some Dutch laws, and made it clear that companies have obligations to be aligned to the Paris Agreement objectives. So this is one type of climate litigation case that we are seeing. We are also seeing cases that involved the due diligence of value chains. So these cases have impacts even in Brazil. So we have the loi de vigilance in France, a law that imposes obligations to French companies, even if they are in other jurisdictions, to conduct a due diligence that involved climate issues in their operations anywhere they are. So we have some French companies' operations in Brazil, and many of these cases were brought in French courts, but claiming ESG, climate change, and human rights due diligence obligations due to their operations in Brazil. We also have, as companies now, they are more ambitious and they are more vocal on their emissions reductions aims. Companies start to publish these in their sustainability reports, but now they have to sustain these claims of reducing emissions or being net zero by 240 or 250. So as they struggle to show that they are in the path to be net zero, there are many climate litigation related cases being brought accusing these companies of greenwashing. So we have a big trend of climate litigation cases related to greenwashing, mainly in European courts. So yes, we are seeing this everywhere. And we also see some cases that are requiring companies to repair for the damages to the climate that their activities impose. And there, Annie commented on the importance of science here. There is an evolving science of attribution being developed, and we are moving forward to a moment in which we'll be able to attribute the specific consequences to the climate change globally to the specific actions of some companies. So today we have a case that was decided in the German courts against a Peruvian farmer that brought a case against a German energy company. And the Peruvian farmer was saying that this German energy company had an impact in his farming activities because the lake that was in his property, his real estate, was raising, and he was losing grounds to have his crops. This case was decided today. We can comment that in a future event of arbitration channel, but this is being celebrated by, for example, the Grantham Institute and other institutes that are following up this climate litigation trend as a very important precedent. Coming to Brazil, I am seeing in my practice daily many cases, public civil actions against companies from the energy mining sector that dispute issues connected with environmental licensing of these activities. And these cases are becoming climate cases. In the middle of these cases, many times, public prosecutor's office are bringing a new request to the case, saying that the environmental licensing of these projects should only consider the climate risks of those activities. And in spite of the fact that this is not clearly mandatory under Brazilian laws, we had a very important ruling from our Supreme Court from 2022. It's a ruling from the Minister Luiz Roberto Barroso. It's ADPF 708. If anyone that are hearing us are interested in reading this precedent, and basically what Minister Barroso decided was that, and I have a quote here from this case that was decided in our Brazilian Supreme Court. Basically, the Justice Barroso claimed that the international treaties that address environmental law, and he was specifically mentioning the Paris Agreement, has a super legal status. So in spite of the fact that the Brazilian laws perhaps might be seen as not so clear about the obligation of governments and companies in Brazil to consider the Paris Agreements, he states that this treaties has super legal status. And then he goes over to say that treaties on environmental law are a form of human rights treaties. So this is another trend that we are seeing in climate litigation, the connection between environmental, climate, and human rights. This nexus is very clear in every case in every precedent that we study in relation to climate litigation cases. And so he says that he goes over and say that these treaties are entitled to supranational status. And therefore, there is no legally valid option to simply omit to combat climate change. He goes over and say that governments in Brazil at every level, federal level, state level, municipal level, should abide to the Paris Agreement, should consider that. And this is, I'm seeing this reflecting in the last couple of years in the climate litigation cases that I'm litigating in Brazil. So public prosecutor's office are feeling encouraged and are referencing this case that was decided in our Supreme Court and bringing the discussion of climate specific climate risk assessments being made in environmental licensing projects in Brazil. So just to give you a very on the ground, the situation of climate risk being brought to environmental litigation, and also reflecting, as I commented earlier, on agreements dealing with carbon credits projects, for example.
Can I just make a... Oh, sorry, Daniela, go ahead.
No, go ahead, please.
No, I was just going to make a very, very short comment because Luis, discussed climate change-related litigation. If you're looking for a great database of all the climate-related litigation going on all over the world, there's the Columbia Law School. They have the Sabin Center for Climate Change Law, and it's a great database of all the ongoing kind of climate change-related litigation occurring in the US, but also globally. So I just wanted to mention that very briefly.
No, it's perfect. Actually, two things I wanted to say. The first one, you mentioned about the ICC report. I forgot to mention as well about the IBA report. That it was a very good report as well about ESG and clauses, and it's a good one to have in mind. And Luis mentioned about human rights. That came to my mind. To come back to the basics, because all we do is to have a better society, right? And all we do.
I'm sorry to interrupt, but there's some voice interruption. Is it only me who can hear it?
Sorry,
I hear it too. It's your microphone, I think, Daniela.
There's some issue with your microphone.
Can you hear me better?
Little better, but I think it's still there.
It seems that there is some interference in the micro, Daniela.
Okay. I think there's some challenge. Try speaking now. No. Can you maybe try rejoining or something?
I think Mac, it's fine from your side. I think it's a problem from her side.
Yeah. Maybe it's the earphones or something. Okay, so yes, a very classic example to start the next question. Technology has its own pros and cons. Technology, of course, is connecting us, but of course, there are some drawbacks as well. My next question, I would like Annie to start with it. How do you think technology can assist in addressing current environmental issues, especially in context of arbitration? Maybe when we are discussing, we can talk about use of AI, blockchain, remote hearings, and in ESG arbitration. And also all these online dispute resolution platforms that are coming up right now, how they can provide access to justice in ESG disputes, or specifically talking about, just to kickstart, in India specifically, a lot of hearings, court hearings and everything went virtual during COVID. Before COVID, I've never sat in a Zoom call. We had no other option but to resort to technology then. And as I said, ESG is a buzzword. Another buzzword is AI. And Annie, I think it's your area of expertise. You can take a lead on this, and then all the panelists can pitch in their inputs about technology, arbitration, and what is their take, what happens in their jurisdiction. Over to you.
Okay, thanks, Mahak. So a full-packed question there. How can technology assist in addressing current environmental issues, especially in the context of arbitration? So I do think technology is playing an increasingly powerful role in how we address environmental issues. And this is especially true in the context of arbitration. As ESG obligations become more complex and widespread, technology is helping us not only manage disputes more efficiently, but also prevent them, monitor compliance, and ensure greater transparency and accountability. So let's break it down, and let's start with artificial intelligence, AI. So in the context of ESG arbitration, AI is already proving to be a valuable tool. One of its most immediate application is in data analysis. So ESG disputes often involve massive volumes of data, including, for example, emission logs, climate risk disclosures, satellite imagery, supply chain audits. And so AI can process and analyze this data far more quickly and accurately than any human team ever could. So let's say, for example, you have a dispute, there's a dispute over a company's carbon emissions, then AI could analyze years of sensor data to detect patterns of non-compliance or anomalies that might otherwise go unnoticed. And that kind of insight can be critical in either preventing a case or at least building it out or defending a case. AI can also be used to review contracts and identify ESG-related clauses such as sustainability covenants, environmental warranties, or climate-related force majeure provisions. And this is particularly useful in large-scale infrastructure or energy projects where dozens or even hundreds of contracts may be involved. So in a supply chain dispute, for instance, AI could flag whether a supplier breached a sustainability clause by sourcing materials from an environmentally protected area. Another emerging use of AI is predictive analysis. AI tools can help parties assess the likelihood of success in arbitration based on past outcomes, tribunal composition, and legal arguments. This can inform, obviously, case strategy and even encourage settlement. Predictive analysis is not perfect yet, so I don't necessarily recommend that people rely on these types of tools, but still, it gives you some form of insights, at least on that front. And then finally, in terms of natural language processing with AI, AI can extract key facts, obligations, and timelines from ESG reports or regulatory filings, making it easier for counsel and arbitrators to navigate complex documentation. Now, if we turn to blockchain, Blockchain is perhaps a bit less familiar in legal circles, but it is equally transformative. So at its core, blockchain is a decentralized, tamper-proof digital ledger. In essence, that's what it is. It records transactions in a way that is transparent, secure, and immutable. And this makes it incredibly useful for ESG, where trust and traceability are essential. So one of the most promising applications of blockchain is in supply chain transparency. Blockchain can track the origin and the journey of goods, ensuring that ESG standards are met at every stage. So for example, let's say in a dispute over sustainable sourcing, blockchain records could prove whether raw materials were obtained from certified environmentally responsible sources, and this kind of verifiable data can be decisive in an arbitration. Blockchain can also be used to store, for example, environmental performance data such as carbon credits, water usage, or biodiversity effects in a way that cannot be altered. In a dispute over carbon offset credits, for example, blockchain could verify whether the credits were double counted or fraudulently issued. This kind of immutable evidence is particularly valuable in cross-border disputes where trust in the data sources may vary. Another powerful application is in the use of smart contracts. So smart contracts are self-executing agreements coded on a blockchain. They automatically enforce obligations when predefined conditions are met. So imagine a renewable energy power purchase agreement that includes a clause adjusting pricing based on real-time emissions data. A smart contract could monitor those emissions and automatically apply the price adjustment, or even trigger a dispute resolution process without human intervention. So this not only increases efficiency, but also reduces the risk of non-compliance. You mentioned, Mahak, the growing role of remote hearings and online dispute resolution platforms. I think remote hearings have become, the standard since the pandemic. And for ESG disputes involving parties in different jurisdictions, to make arbitration, because arbitration, in and of itself, the process can be has an impact on climate. People travel if they go to in-person hearings and all of that. So having these remote hearings make arbitration as a process a bit more ESG compliant as well. And then online dispute resolution processes, I think, also help, for example, some small businesses or communities that would have less access to the typical forums to be able to, access arbitration and participate in a way that makes sense for them at a lower cost. So if we bring it all together, technology is not just a tool, it's truly a bridge. It connects the data to accountability, the parties to the process, and AI helps us make sense of complexity. Blockchain, by analyzing vast amounts of data in seconds. Blockchain helps us build trust and automate compliance, and remote hearings and ODR platforms help us make ESG arbitration more inclusive and accessible. But there are limitations to these tools around data privacy, algorithmic bias, procedural fairness. One thing we could think about in terms of smart contracts, smart contracts, for example, what is the legal recognition of these types of contracts in various jurisdictions? How do you embed these, ESG standards? How do you make sure that they're embedded within the algorithm behind, the smart contracts that are verifying whether, the parties are being compliant with the contract? How do you make sure that I don't know how that is done, And then there's a whole question of data integrity. Smart contracts can only be reliable as the data they receive. And then there might be different standards in various jurisdictions. How do we make sure that we're all on an equal playing field on that front? So again, I'm not saying technology is perfect. because there are humans behind the technology that are operating those technologies, and there are various standards across different jurisdictions. But it's still a valuable method moving forward in terms, especially in relation to ESG, I think, disputes, in terms of making the data perhaps more reliable, as I was explaining, analyzing the data in terms of with AI, and accessing arbitration for those more kind of remote or participants.
Annie, technology is perfect when it works. As I was saying, is my microphone working, and are you hearing me now?
Yes, very well.
Unfortunately, I had to travel, and I'm in a hotel, so it was perfectly working, and suddenly it didn't work. So technology is perfect when it works, but eventually it doesn't work. So it is perfect because we have people in India, we have people in Canada, we have people in Rio. I'm in São Paulo. It allows us to do what we are doing right now. But unfortunately, sometimes it doesn't work, and it really clash everything when it doesn't work, as it clashed Mahak, who is not with us anymore, as I'm she's coming back. She's coming back. As I was saying, Mahak, technology is perfect when it works, but when it doesn't work, it's really and it gives us anxiety, right? But anyway, I was saying to Annie, it gives us as well precisely what we need regarding to audit as well. Carbon market could not exist without blockchain, and the certification would not exist with the black market. The carbon credit would not exist with the blockchain and certification, etc., etc. So it's what gives us the hope that we will be able to do something about the existence of good carbon markets around the world. Yeah. But I would ask as well another, I would add as well another example, that in one of the arbitrations, I was a client, I was general counsel. We had a very difficult proof to bring to the arbitration tribunal, because it was a huge mechanism in the automotive industry. So we did with the virtual glasses, So we filmed, and then we brought to the tribunal in the audience room, and they all put the glasses, and they all could see the film in and they could do the 3D visit that was really cheap, instead of taking everyone to the plant that was very distant from the siège of the arbitrage. And it was technologically speaking very, very interesting.
Yeah, so virtual reality. Yeah.
Virtual reality, yeah.
But then it raises a number of questions, like, is that virtual reality truly like if you were a side visit?
It was with the audit. It was auditable. Okay. It was with the expert. It was filmed with an audit, the presence of an auditor. So it was okay. Yeah.
So basically, I think the question was on evident value of how virtual reality can be used, and if auditor was there, I think it suffices the purpose. Also, when I'm talking in terms of India, this ODA loop is there, organize, orient, detect, and act, which is majorly for in terms of when you're using AI in war and all, but it's also very compatible when you're talking in terms of arbitration and artificial intelligence being in arbitration. There are a lot of chatbots, negabots, which at particular stage help us to resolve certain small matters which could lead to a bigger disputes. But as I feel, when you're talking in terms of arbitration disputes, you have to you cannot rely completely on AI. You have to have a human intervention somewhere, at least at the time when you are deciding, or you cannot just go to AI and or Chat GPT or Gemini or any other consensus and you say that okay, draft so and so. In particular case of this, though there is a very high probability that because of his hallucination and black box syndrome, they may give you a result which you're not actually waiting for. So, but on the other side, we see there are a lot of companies, big tech firms and big, Amazon and Alibaba and all, they're using to resolve disputes, their online platforms. And also there are a lot of online dispute resolution. No doubt there is a question, I think will be the next one on ODR. But there are a lot of ODR mechanisms there around the globe. And in India, I know some of my juniors from my same college have started a ODR platform, and in India, Sama and all are well-known platforms. So there are 8 to 9 online dispute resolution platforms in India, working in different domains. Some of them are really working very fine. Some of them are trying to cope up with the market competition that is there because of the other ODR system. So this technology as being like, earlier, most of the things when you talk in terms of ADR and things. In India, people think more of courts rather than ADR. And then there was around a decade back, people have started thinking of alternative dispute resolution. And then in the last 5 years, people have also switched to online dispute resolution, knowing the benefits of it, especially to big firms and all. It's a great help. And the only issue is sometimes when you leave everything on artificial intelligence, on the digital techno or the digital technology. So some form of human intervention is required. And I always support that AI should not replace, or digital technology cannot or should not replace us.
But Dr. Niteesh, I would have a question for you about the governance, the G of ESG, the governance of those platforms. How is the governance of these? Would you know, or would you have something to tell us about this?
On a very honest note, I have worked because since they were my juniors, I was, when they were developing this concept, and me and Mahak Mahak is a entrepreneur turned advocate, and I'm an entrepreneur turned academician. So we started certain platform which is well known in India, and then because these people, when they started, they contacted me personally that we wanted to go for this and we wanted to start. On a very honest note, there is nothing much in terms of legislation to control them, and they have no guidelines on how ODR needs to work and what is the regulatory insight for them. So in India, they're working freely like an entrepreneur set up like a startup. And they are called as a startups, to be honest. So if you just go online, you type Indian startups on online dispute resolution, you will get around 8 to 10 websites which are providing these services, but there is no government and regulatory oversight over them. So they're free to work they want. And when you're talking on ESG governance part, then I think their governance itself is in question mark. Then how they are able to, decide the governance of other is definitely a good question to be asked.
Good, thank you. Okay.
Yeah. Thank you. And me losing connection was the best example of both the pros and cons of technology. But what I could gather, of course, Annie, thank you for highlighting and starting this question on the right note, letting us know about AI, about blockchain, smart contracts, and everything. And of course, then Dr. Niteesh highlighting ODR and specifically the platforms that are there in India. And one thing that I can gather is, of course, technology is here to stay. Technology is going to evolve, so it's important that I think we, get used to it, we get acquainted to it. Another follow-up question that might come, maybe it's been discussed when I was disconnected. In India, what I've witnessed is with the growth of technology, there are new models coming up. Technology is growing at a very fast pace. Cyber crimes are also developing at a very fast pace, and they are targeting the vulnerable sections, the children, elderly, who are not, used to being attacked this way. So when we specifically talk about these platforms, the ODR platforms, just one question that came to my head. How do you think we maintain the security? How do you think these platforms are secure, the data protection concerns, and how is the situation? And can you just highlight us, put your experience to this?
Yeah, I can share a little bit on that from Yusmundi's perspective, because we are a database of information in arbitration, and we have now added a layer of Gen AI on top of our database so that our users can search the entirety of our database with natural language and asking questions like through a chatbot, but also our users are able to upload their own documents to the tool to be able to interact with those documents and our database. And obviously, in terms of security for any type of provider, this is like super essential, because you want to make sure that you have that trust with your users. And so first, there are a number of certifications, like there's ISO certification to make sure that the platform remains secure, that everything is encrypted. What we've done as well as a company, for example, we're participating. We actually launched this contest where hackers can come and try and hack our systems. And if they manage to breach our systems, then they win a prize. So we actually put money in their hands to try and help us, identify any potential areas that where the platform might be less secure. But again, we've gotten our ISO certification on that front, and then we obviously have what we call the CISO, which is a Chief Information and Security Officer at the company. And his role is only to do that, to protect the system, and there's somebody working full time doing that internally. So obviously, any type of provider, has to offer good security instances. And obviously, every time a new client comes on board and wants to subscribe to our services and have access to our Gen AI product, usually, we have to go through all of their security requirements. So we are in constant discussions with, law firms' IT teams to make sure that, we are compliant with whatever security requirements they have or the law firm has as a whole.
Thank you so much. And I think, it was important to see how Justmundi is working. And it's amazing to know that, you are inviting hackers to try hacking your system. That's fantastic. Coming to Luis, just for your concluding remarks on this topic.
I don't have much to add, just to emphasize the importance of technology for the integrity of carbon markets. So we have a big crisis. I would say we had a big crisis of integrity of carbon markets, and the developments of technology is crucial for rescuing the integrity of carbon markets worldwide. So, and we are already seeing many of these carbon projects methodologies being updated, and we are seeing the technology is central to allowing parties interested in buying these carbon credits. They can really rely on the assessment of how this carbon credits really relates to tons of carbon that were avoided or tons of carbon that were captured from the atmosphere. So we see that technology is being central in rescuing the integrity of carbon markets worldwide. So this will be my main comments. And of course, this reflects on the arbitration cases and all other ADR cases that we have been involved. It's crucial to have it right, so that parties can come to an agreement in terms of reality, avoiding double counting, in terms of capturing and avoiding carbon dioxide emissions.
Mahak, if I may, I would say that if we need to go further in the world in terms of ESG, carbon market, and standardization about ESG methodology between BRICS plus environmental methodology. What is, in my opinion, and I would like to hear Luiz about that, is the taxonomy within BRICS plus countries, because Brazil, for example, has not finished the taxonomy, meaning what are the methodologies that will be applied, the values, what will be valuable or not, accepted or not, to value carbon market, carbon emissions, etc., etc. So, Luiz, do you agree with me or not?
That, Daniela, I think there is a big opportunity for BRICS countries to come together and try to come to one only solution, or at least solutions that can talk to each other in terms of the reliance of the methodology that is being used. Of course, we have some highly regarded accrediting institutions that worldwide are used for carbon credits.
Yeah.
But we still need some negotiation between BRICS countries to adopt this methodology and to decide on the accepted methodologies.
Because I think this could be a very big source of problems in the future if we don't have the same the standardization of taxonomy. In the future, we can have a lot of disputes about this.
Yes, you're right, Daniela. And Brazil is building its taxonomy. It's taking a while, but I think we are moving forward. And all the BRICS countries should talk about aligning their own taxonomies, not only for carbon markets, but also
for everything. Yeah.
For certifying activities, for
environmental services, and etc.
Of course.
Yeah. Thank you to all the panelists. I think we've wrapped up the technology question, and thank you, Daniela, for the question that you've popped up. Now the time has come for a very quick rapid fire kind of question answer session with all the panelists. And if anyone who's watching us, you have any question, you can put it out here. I would be happy to take that question, and the panelists would be happy to answer the question. So the rule is, I'll tell you one question, I'll make one statement, and you have to answer it very briefly, what your take is on that. We have discussed about ESG, we have discussed about arbitration, we have discussed about climate disputes, we have discussed about technology. And we have also discussed what is the situation in each jurisdiction that the panelists are from. According to you, what kind of reforms would you like to see in your legal system to better support ESG arbitration? Annie, maybe we can start from you.
Putting me on the spot there, Mahak. Well, it's not necessarily pertinent to Canada per se. It's more a general kind of remark. And I think it goes back to a point Daniela made, which is I think we need more education for arbitrators on ESG, climate change. I'm not sure, has the ICC or some of these institutions, do they have specialized rosters for these types of disputes? I don't think so. Maybe we need more training on that front as we go along. So that would be my 2 cents on that.
Thank you. So your major input is education for the arbitrators. Daniela, what's your take on this?
I would go with her. And I would take the taxonomy as well, because it's something that is really lacking for us to move on. and carbon market.
Amazing. Luis?
I agree that that figure that I used in the beginning of our panel, that arbitration and environmental matters are seen as electrons that repel each other, but they should not be seen like that. So coming back to Annie's point, education in both communities, they are kind of separated communities. So initiative like this one that we are having this morning, and all of this ADR week focus on ESG issues is important to be replicated, because these two worlds kind of don't talk to each other. We are seeing they are talking every day more, but they don't talk to each other. So we have to put together arbitration practitioners and environmental ESG practitioners, so they will be able to come together and come to solutions that will be better for everyone. So we need to replicate initiatives like this one.
But by the way, what we are doing, and this is what I was about to say when my micro didn't work, is what we do is to have a better life for people, about people, with people. So we are talking about people, right? And because Luis talked about human rights. So what we do is to preserve sustainability is to preserve scarcity, and scarcity is actually a known driver of conflict. So we are trying to prevent conflict, preserving sustainability. So if we don't talk about people that are driving sustainability and well-knowing sustainability, we are not talking about human rights, for human rights, with people. So this is what we want to promote with this week, and I will try to promote it Glass Forum. Thank you for everyone.
Can I add something to that? Because I think it's an important point, Daniela, you're making. You know, all of these environmental related dispute, climate change dispute, there's always there's a human component, there's a public policy interest in those types of disputes. And this is the question sometimes I have, you know, vis-a-vis arbitration, which is not always a transparent process. More often than not, these arbitrations are confidential. And, you know, this is something that Jus Mundi has been fighting a little bit. I think we brought a lot of transparency in arbitration by, you know, making arbitration awards that are non-confidential or accessible. And we need to have a growing body of jurisprudence, of awards that are freely accessible so that we can build a corpus of decisions in this space. I mean, obviously we have the national court decisions, and you've mentioned some of these, Luis. But on the arbitration front, if we want to bring more, you know, if we were able to bring more transparency and have some of these disputes, you know, parties you know, decide that the dispute shouldn't be confidential, I think would be helpful for the arbitration community, the environmental community, to see, you know, what is coming out of arbitration. And I think that's what we've been trying to do at Jus Mundi, and hopefully we'll carry on our work on that front.
By the way, my first Glass Forum board meeting was within Jus Mundi offices in Paris. So
Wonderful.
Jus Mundi has been supporting us very much.
Wonderful.
And you've answered the next question also that I had in Fireside Chat about transparency and accountability through technology. Jus Mundi is doing great when it comes to transparency, accountability, and how you're using technology. So I just have another 2-3 minutes to conclude the whole thing. So very quickly, maybe you can raise your hands. Is there a possibility for BRICS ESG arbitration forum or collaborative mechanism to emerge in near future? Would you want to see that? Anyone? Daniela?
Sorry, I didn't hear very well. It cut.
Okay, my bad. So the next question is there a possibility for a BRICS ESG arbitration forum or a collaborative mechanism to emerge in the near future?
Yes, Glass Forum.
Okay.
I think everyone can have just a wrap up, 1 minute talk. It's 11:56. We just have 4 minutes. Everyone can have 1 minute wrap up and say bye bye. But thank you very much for everyone to be here. It was a pleasure.
Yeah, thank you so much, everyone, for joining us. Thank you, Arbitration Channel. Thank you, Daniela, Elizaveta, for organizing this and for inviting us. Just as final concluding remarks by each panelist, maybe, Daniela, I would invite you again to give the concluding remarks very quickly.
No, but maybe I will do it at the end. Annie and Luis, please.
Well, I think, we certainly don't have answers to all of the questions. I think that this is an emerging and constantly evolving field. I think there's a lot of potential moving forward in this specific field, despite the geopolitical shift that we're seeing. As Daniela mentioned, this is going back to we're all humans, we're all sharing this planet, and we all need to, there's a finite amount of resources for a growing population. And so, we all need to work together to ensure the well-being of our respective communities moving forward. And I think BRICS has a unique opportunity, as I mentioned in the beginning, to position itself as a bloc to be leaders in this space, as other countries are taking a step back, unfortunately.
Thank you.
So, just as a final remark, I have been dealing with this connection between arbitration and environmental law for already 20 years, and I can definitely say that we are moving forward in having definitely a more increasing acceptance of the idea of putting these two electrons together. Perhaps one become proton, another an electron, and they will be closer. And I see in these last 15, 20 years, mainly in the last 5 years, that they are becoming closer. And initiatives like this one, as I said before, are crucial for these communities to talk to each other. The solutions to the most challenging issues of humanity requires multi-practice approaches. We cannot be only dealing with our niches and our specialization backgrounds to solve this problem. So we need to be together. So again, just thanking the Arbitration Channel, Danielle, for inviting me. And I think you have to replicate initiatives like this one.
Thank you very much. Thank you very much, everyone. This is a space where we are, for the first time, putting different people from different countries and different continents to listen to each other, to come together, because we need to be together. We need to move forward together. This is the purpose of this event, the first of many. And we need different backgrounds. On Friday, my panel, where I will be moderator, will have a specialist from circular economy. She's not an arbitrator. She's not from legal world. She's from the circular economy. This is different people we need from different mindsets to talk as well from listening at different worlds. And this is from when we will go further. So thank you very much, Mahak, for being here moderating this exceptional panel, Annie. And unfortunately, because of technology, we lost one of our dearest panelists. Luis, thank you for being here. We have been together since many years as well. We have the pleasure to have worked together in different sites, but not as lawyers, but as consultants. And I was a general counsel and you were in a law firm, and we met many years ago. So it was a pleasure as well to be in this panel with you. So thank you, everyone. And ladies and gentlemen watching us, thank you for being with us. And Arbitration Channel, thank you for supporting.
Thank you very much.
Bye-bye.
Thank you so much.
Thank you.
Bye-bye.
Bye-bye.